Good morning, everyone. Welcome to today's presentation. I'm excited to discuss vicarious liability with you. This is the first slide, so I want to start by introducing the topic. As you can see, the title is Vicarious Liability. We'll be exploring what it means, how it applies, and some key examples. Over the next few slides, we'll cover the essentials, including legal principles and practical implications. So let's dive in and get started. Today, we're exploring vicarious liability within administrative law. This concept refers to the connection between sovereign and non-sovereign governments, or in simpler terms, between the master and servant. Essentially, it's about how the state's liability for wrongful acts is tied to the actions of its officials or agents. When we talk about the state's tortious liability, we're referring to situations where the government itself is held responsible for harmful conduct carried out by its employees or representatives. A helpful explanation comes from Winfield, who describes vicarious liability as the potential for one party. Let's call them to be held liable to a third party. C, for damage caused by another party. B, importantly, A doesn't need to have directly participated in the wrongful act, nor does a need to have breached any legal obligation towards C. It's about the relationship between A and B, and the conduct of B that results in liability. This idea is fundamental because it shows how liability can be transferred or attributed without direct involvement, which is especially relevant when analyzing how governments or authorities are held accountable for their actions or the actions of their officials. It ties back to the overall theme of understanding the scope of government liability and its implications. Let's take a closer look at Article 300(1) of the Indian Constitution. This article essentially states that the government of India can be sued in connection with its own matters, such as the Dominion of India. Think of it as a way to hold the government accountable within the legal system. Before the Constitution came into effect, any lawsuit related to India's dominion would have been filed against the government itself. Interestingly, during that time, Parliament did not have the power to enact laws specifically for such matters. Also, the state legislature didn't pass laws when the Constitution was adopted, which reflects the legal context of that period. Now, what happens when Parliament doesn't pass the necessary laws and a government servant commits a tort? In such cases, the accountability falls on the Secretary of the State Council. This points to how responsibility is assigned when legislative action is lacking. It's also important to remember the historical background. Before the current constitution, the governance of India was shaped by the East India Company and the Government of India Act of 1858. That act transferred the control of India to the British Crown, making the Crown responsible for the government's liabilities and powers. Understanding this history helps us see how legal accountability and governmental liability have evolved over time, tying into our broader theme of governance and legal responsibility in India. Let's start by exploring the concept of master and servants, which is fundamental in understanding the relationship between principals and agents. The principle here is that a master or principal is responsible for the acts of their servant or agent, especially when those acts are performed within the scope of their employment. This naturally leads us to think about how firms operate, with partners working together, often sharing responsibilities and liabilities. Moving on, a key area of discussion is the state's liability. Specifically, the doctrine of sovereign immunity plays a crucial role. Historically, this doctrine meant that the state or the crown couldn't be sued without its consent. However, over time, legislation like the Crown Proceedings Act of 1947, the Federal Torts Claims Act of 1946, and Article 300 of the Indian Constitution have paved the way for holding the state accountable in certain circumstances. These laws essentially provide mechanisms for suing the state, balancing sovereign immunity with accountability. Next, let's consider joint tortfeasors and the concepts of joint and several liabilities. When multiple parties commit a wrongful act, they are called joint tortfeasors. Legally, this often means that each party can be held responsible for the entire amount of damages. This is joint and several liability. It ensures that the injured party can recover compensation even if one of the wrongdoers can't pay. Finally, I want to highlight the principle of vicarious liability, which is closely related to the master-servant relationship. Vicarious liability means that an employer or principal can be held responsible for the wrongful acts of their employees or agents, provided those acts are done within the scope of their employment. The basis for this principle is rooted in the idea of control and the need to ensure accountability, especially when the wrongful act benefits the employer or is connected to their business. All these points together help us understand the legal framework that governs relationships, responsibilities, and liabilities within organizations and between the state and its citizens. When we think about responsibility, generally, a person is accountable for their own wrongdoings. That's straightforward. If I commit a wrongful act, I'm the one responsible. But it becomes more complex when we consider the wrongdoings of others. Typically, we aren't responsible for what someone else does. However, there are situations where vicarious responsibility comes into play. That's when one person can be held accountable for the actions of another. Think of it as a kind of indirect accountability. This can happen, but only under certain circumstances. For someone like it to be held liable for what B does, there needs to be a clear link between them. It's not enough for B to act wrongly. There has to be some sort of relationship or connection that ties it to B's actions. And importantly, the wrongful act must be connected to that relationship in some meaningful way. So, the key idea here is that liability isn't automatic. It depends on the nature of the relationship and the context in which the wrongful act occurs. This concept helps us understand how responsibility can sometimes extend beyond the individual to others in certain legal or ethical situations. So the phrase, qui facit per alium facit per se, is a Latin legal expression that translates to he who acts through another acts for himself. This is a fundamental principle in agency law, and it's often used to address questions of liability, especially when considering an employer's responsibility for an employee's actions. The core idea here is that if a master or employer is naturally responsible for performing certain duties through the use of servants or employees, then they are also responsible for the actions of those servants. Essentially, if the master employs someone to do work, it's as if they are doing it themselves. This principle is a condensed version of a longer 18th century formula. Qui facit per alium est parend acc facit per se ipsum. It emphasizes that acting through another doesn't diminish responsibility, it actually maintains it. And the key phrase to remember is QUI FACIT per ALIUM FACIT per SC, which reinforces this idea that acting through someone else is equivalent to acting oneself, especially from a legal standpoint. This concept is important because it helps us understand liability in situations where actions are carried out by agents or employees on behalf of a principal or employer. It ties into the overall theme of accountability within agency relationships. The master has the largest bank account. In some situations, a defendant's wealth or the fact that they have access to resources through insurance can unintentionally influence how legal rules are shaped. This is an important point because it shows how financial power can impact justice. Now, vicarious liability is a concept that supports accident prevention. It does this by giving employers a financial incentive to encourage their staff to prioritize safety and consider the well-being of others. Essentially, if employees cause harm while working, the employer can be held responsible. Since employers profit from their employees' activities, it's only fair that they also bear the losses that come from those activities. This aligns accountability with the benefits gained, ensuring that those who benefit financially also take responsibility for the outcomes. So, the main reason for vicarious liability is to create a system where safety is prioritized and responsibility is shared, especially when the employer benefits from the work being done. It's about fairness and encouraging safer practices in the workplace. Let's take a look at the origins of vicarious liability. The term itself was actually coined in England. Back in the day, there was this legal maxim, Rex non potest pecare, which means the king can do no wrong. During the reign of an ancient king, this principle was in effect. What that meant in practice was that if a king's servant committed a tort or a wrongful act, while working on the king's behalf, the king himself wouldn't be held liable under the doctrine of vicarious liability. Essentially, the law shielded the crown from being responsible for the actions of its servants. However, as government responsibilities expanded and society evolved, this exemption for the crown started to clash with notions of justice. It became clear that it was no longer fair or just to deny the crown liability in such cases. In some instances, the king's court actually pushed back and refused to uphold this exemption, arguing that it was against principles of justice, equality, and good conscience. Over time, this shift reflected a broader move towards holding those in power accountable, aligning legal principles with evolving ideas of fairness. So, looking at the past, we see how the concept of vicarious liability has developed from a position of absolute immunity for the crown to a more balanced approach that considers justice and fairness. This historical context helps us understand the foundation for modern liability principles we're examining today. Let's talk about the old and fundamental idea that the monarch can do no wrong. Now, this phrase doesn't mean that the king is above the law or that everything he does is automatically just and legal. Instead, it has two main meanings, depending on who you ask. First, it means that if something unusual happens in managing public affairs, people don't usually blame the king personally. He's not held personally liable or responsible for every decision or mistake. Second, it emphasizes that the crown's prerogative, or the royal powers, are meant for the benefit of the people. They shouldn't be used to harm or hurt others. In fact, English law doesn't give a way to condemn or force the king to make restitution if he's wronged someone. As Maitland pointed out, the king can't be condemned or compelled to act against his will. So, while the phrase suggests that the king can do no wrong, it's more about the legal and traditional limits on royal power, ensuring that the monarchy serves the people and not itself. This concept ties into our broader theme of understanding the balance between royal authority and the rule of law. According to Article 300I of the Indian Constitution, the Government of India has the authority to sue or be sued in the name of the Union of India. Similarly, the government of a state can sue or be sued in the name of the state. This applies in matters related to their respective affairs, and importantly, they can do so in cases that are similar to those where the Dominion of India or the Indian states might have previously initiated or faced legal action. As per Clause 1 of Article 300, neither the state legislatures nor the Parliament have enacted specific laws to detail this process further. The current understanding is that if a claim is made against a state, it would be liable for damages, much like an analogous province would be. From a constitutional perspective, this setup ensures that both the central and state governments can participate in legal proceedings in a way that preserves their sovereignty and operational integrity. It also highlights how the legal framework is designed to facilitate accountability and resolution of disputes without overstepping constitutional boundaries. Overall, this provision underscores the balance the Constitution seeks to maintain, allowing governments to function effectively while ensuring they can be held accountable through the legal system.